Hey all, welcome back to the Law Read Slowly. In the last session, we had completed the case of South India Church Association versus the Telugu Church Council, and we had already started with the topic of jurisdiction. I had explained to you what is the purpose of the idea of jurisdiction in the civil courts and why do we have it as part of the civil law. What is the larger aim behind it, that the courts do not get clogged and that not one court is ending up with all kinds of cases while the other court is sitting idly, because that is going to lead to what? A wastage of resources, and it will slow down the wheels of justice. We also then moved on to discuss what are the three kinds of jurisdictions. We discussed territorial jurisdiction, we discussed pecuniary jurisdiction, we discussed the subject matter jurisdiction, we discussed logic behind each one of those jurisdictions, and we established that whenever it is said that the court should have jurisdiction, all three kinds of jurisdictions must be present. Only one or two of them will not suffice, and that will not give the court jurisdiction to try your case. Now, write this down, whatever we have discussed, now, and keep taking dictation side by side. So, start writing. I'll also pull up the judgment and I'll dictate to you the relevant portions from the judgment that you have to write. I'll give you a paraphrased version so that it's easy for you to understand and it's not very lengthy, so that you can keep it in your notes and you can just read that and refresh all that we have discussed. So first write this much. Start writing. Before we, so you can give the top. So somebody wrote to me that if it's possible for me to give you headings for dictations. I don't find the reason to give them all the time. But if you're requesting, then you can take down a heading for this dictation. You can write jurisdiction, introduction to jurisdiction, comma, comma, competency, competency, and and the meaning of and the meaning of a competent court, the meaning of a competent court. So this is the title that you can give for the dictation that I will give you today, and you can continue writing under it. I'll tell you where to break paragraphs, where to change sentences, but this is the topic you can use. But otherwise, also, I would say that when we are writing in class, whenever I'm discussing a topic, you should be able to yourself give a title to that discussion, because that is the real test of whether you have understood the topic well or not. Because you should be able to drive out the crux, the essence of the discussion, that yes, this is what the discussion has been centered around. And then automatically you can give your own topics. Even this topic is not, you're not bound to it. You can give your own title, you can give your own subtitles, whatever way makes it more navigate, it's easier to navigate for you through your notes. That's how you should go through it. Now start writing. So first I'll make you write a small intro paragraph, and then I will make you write what is jurisdiction. Then I will make you write the purpose behind jurisdiction. Then I'll make you write different types of jurisdictions that are there. And then slowly we will transition into talking about jurisdiction versus competency. So begin writing. Before we enter the specific provisions, because this is why I'm giving you that explanation about purpose, aim, meaning, because eventually what we're going to do, we're going to discuss the provisions of CPC to understand jurisdiction. Before we go into the provisions, I want you to have all of this in your mind, so when you read the provision you're not lost. So before we enter the specific provisions dealing with jurisdiction under the Code of Civil Procedure 1908. Under the Code of Civil Procedure 1908, it is necessary to understand what the word jurisdiction, you can put jurisdiction within single inverted commas or double inverted commas, jurisdiction means in the legal sense. What the word jurisdiction means in the legal sense. CPC does not define jurisdiction. The word jurisdiction is not defined in CPC. CPC tells you how jurisdiction will be conferred, territorially, subject matter wise. It just tells you directly about that. So it presumes that you already know the meaning. So it's my job to set that presumption in your mind, to give you that knowledge that CPC already presumes you to have. So, in the legal sense, full stop. Jurisdiction refers to the lawful authority of of a court a court to hear, comma, try, and decide a matter, full stop, full stop. It fixes the competence, competence, comma, authority, authority, comma, territorial area, territorial area, and and other legal limits, and other legal limits within which a court may a court may exercise its judicial power, its judicial power, full stop, full stop. In simple terms, in simple terms, comma, jurisdiction, jurisdiction answers the question, question, put a colon, colon is two dots, colon, which court has the legal power to decide this dispute? Which court has the legal power to decide this dispute? Question mark. Question mark. Correct? That's the simple question that jurisdiction asks you. That's the only question you need to ask. Once you ask that question, all of your discussion on jurisdiction flows out of it. Because how does a court have the power? Territorially, it should have power. Pecuniarily, it should have power. It should have the power in the sense that it has the power to try suits of that nature. So it should be a civil court. It should be a suit of civil nature. It should be the kind of suit if the court has special jurisdiction. For example, if it's a rent court, then your dispute should be such that it's a rent related dispute. Only then will you file it in that court. Next paragraph. The idea that it's a rent related dispute, only then will you file it in that court. Next paragraph. The idea of jurisdiction performs an important, so this is the purpose behind jurisdiction. We've discussed it at length across two different lectures. So now write about it. The idea of jurisdiction performs an important organizing function in the administration of justice. In the administration of justice. Full stop. It tells litigants, people who are going to fight their cases in the court, litigants, which court they must approach, and it tells courts, which matters they are authorized to decide, and it tells courts which matters they are authorized to decide. We've discussed this dual function of jurisdiction. Not only does it tell you where do you file your case, it even tells the court if the court is competent to try that case, because you may not know exactly, although you are supposed to know the law. Ignorantia lex non excusat. Ignorance of law is not an excuse. But still, the courts should know. So if you filed your case in the wrong court, the court that does not have jurisdiction, which lacks jurisdiction, then the court should also know that yes, it lacks jurisdiction in this case, and hence it can take next steps. That's the next topic also that we're going to discuss. What will the court do when you file your case in a court that does not have jurisdiction to try it? What can it do? It can return your plaint. That's just one option that it has. There are 3-4 more things that can be done, which we will discuss when we go to the next topic. So return of plaint is one such thing. When will the court return the plaint? It's the court that will return your plaint. If the court will itself know that it does not have jurisdiction to try this case, then the court will initiate the proceeding of returning your plaint. It's provided for in the Code of Civil Procedure. I'll not reveal the provision to you right now. If you want, go find it out, because we will anyways discuss it as the next topic. Full stop. So we've written the dual function. Now, right, a person cannot file any case in any court merely because that court is convenient, comma, familiar. Because if you live here, you will feel that, oh, why do I have to go to another city? I have to travel and all. I'll just file this case over here. No, you have to file it wherever the jurisdiction falls. Familiar, comma, powerful, Powerful. In the age of social media, we keep seeing different videos from different courtrooms circulating, and if you are in awe of a particular bench of the country and you feel that, oh, I want this particular judge to hear my case, so I'm going to go there and file this case. No. Powerful. I mean, one wouldn't even be talking about this angle of somebody considering a particular bench or court to be powerful and hence filing a case over there. Look at the changes that the law is adapting to as we are moving into the future with social media. Or strategically useful, or strategically useful. Maybe you have a judgment from a particular high court. And what do you know about the high court judgments? How are they binding? They're binding upon the courts which fall under that high court's jurisdiction, and it's favorable to your case, and that's why you want to file your particular case in that particular state only, even though the actual jurisdiction may be another state, because that other state does not have a judgment favoring you from that particular high court, but in this state you do. So you're trying to file your case here, so then you can bind this subordinate court with their parent high court's judgment on the issue and get a favorable decision. So it's strategically useful for you. You can't do that. Full stop. Full stop. The law must designate. Law designates, right? Who decides the jurisdiction? Do you confer jurisdiction on the courts? No. The CPC does. The laws do. The different states courts acts do. The circulars from high court, the notifications from high court and the high court rules do. The law must designate. The law must designate the proper forum. I'm writing you write the word forum because for sometimes it's also called a tribunal. You can also have tribunals trying your case. So there are also forums where you get adjudication done, but they're not called courts, although they fall in the ambit of it. But we are going to use the word forum here. The proper forum before which a dispute may be adjudicated. Full stop. Full stop. Now, also, I want to make you write about. So, this is why we have jurisdiction. What if we did not have the idea of jurisdiction, or rules governing jurisdiction, or rules binding people to file their cases in the courts that have jurisdiction to try their case? Then what would happen? Without rules of jurisdiction, write down, without rules of jurisdiction, comma, litigants would be free to choose courts according to personal convenience, comma, tactical advantage, comma, or remove the comma and write or whim, not VIM, WHIM, whim, your own wishes, your own fancies, your own illogical choices, your own hedonistic choices about a courtroom. That's not what derives you or what renders legality to your fact of filing a case in a particular court. It's the law's rules about jurisdiction that render you that legality. Or whim, comma, and this would create disorder in the functioning of the judicial system. Won't it? It will, right? If everybody's, I told you this example I gave you, if everybody's filing the cases in Goa because they're vying for a holiday in Goa and going for a hearing seems like a good enough reason they can give to their families, they'll just go file the cases in Goa. Judicial system, full stop. Next paragraph. Jurisdiction also helps, to this point we'll write, jurisdiction also helps